Well, why don't we go ahead and get started? Good morning, everyone, and welcome to today's Morning Mug. I'm Jill Cayazzo, Chair of the Arlington Democrats, and I'm happy to be here with you today. For those of you who are not familiar with our Morning Mugs, this is a kind of virtual event that we started during the pandemic. We use these events to talk with candidates or to deep dive on issues of interest to the community. And we have found that the virtual format enables us to connect with even more speakers and even more community members than we would otherwise be able to do at an in-person event, especially one on a weekend morning. So the Morning Mugs have been so successful that we've decided to keep them as part of our programming, even as we return to in-person programming, which we are excited to do. Now, today's Morning Mug features a distinguished panel that is going to help us to better understand a proposal that currently is pending before the Arlington County Board, which calls for the creation of a Civilian Review Board. The Civilian Review Board, or CRB, would provide oversight to the Arlington Police Department in cases involving complaints or police action that result in death or serious injury. We have three speakers who are going to introduce us to this subject. If you could advance the slide, please. First up is our Commonwealth's Attorney, Parisa Tafti, Alexandria City Councilman Seifeldein, and the Arlington Police Practices Group member, Phillip. We're really excited and grateful to have them all here today, and we appreciate their time. Now, before we get to our panelists, I first want to make sure that we can level set on just really the basics of a CRB. Next slide, please. A CRB is a type of civilian oversight body for a police department. It is intended to enhance trust, accountability, and transparency in policing, and the creation of these entities really is part of the national response over the past few decades to concerns about police brutality and abusive conduct, particularly against Black, Brown, and historically disadvantaged and marginalized community members. A CRB can take lots of different forms. There's no one formula, but instead there are a lot of permutations. Common features of a CRB include the fact that they are external to the police department's internal affairs office, that they consist of citizens who are not currently police officers, and that they are appointed by government officials. Now, with respect to the functions of a CRB, those typically include reviewing complaints about police action and making recommendations about disciplinary action after the police department has conducted its own investigation and made its own recommendations. I think it's worth emphasizing that a CRB is not a unique concept. Arlington would not be breaking new ground by creating a CRB. There actually are approximately 150 jurisdictions in the United States with some form of police review board, including a number in Virginia and our neighboring states. One of our very close neighbors in particular, Alexandria, recently adopted a CRB, and we'll be hearing a bit about the Alexandria CRB today. While the CRBs which exist around the country have a lot in common, there are differences in their details. The current discussion in Arlington around a CRB is really focused on certain details. We're going to try to tease out those details during today's discussion with our panelists. Now, let's go ahead and jump in with our panelists, and to make sure that we're all on the same page, I'd like to talk with them a little bit about where we are in Arlington with respect to a CRB. What is a specific proposal for CRB under consideration by the Arlington County Board? And with that question, I note that there seems to be two different versions of the proposal out there. So I'm hoping that our panelists can help us to understand that dynamic as well. I think I'm going to throw this question over to Kim. Can you help us out here with just some basic understanding?
All right, thank you. Thank you, Jill. Thank you for that question. So yes, so there is a bit of confusion. So there is the county manager's ordinance, which the county board voted to advertise. And there's also some alternatives. So the county board made a couple of pretty substantive changes to the county manager's recommendation, including one in which they actually reconvened the Civilian Review Board subcommittee of the Police Practices Group to work out how an investigative authority would actually work in 3 different scenarios. So as we go through this, we'll be talking more about that. And as always, the meeting is on Saturday, so more information is coming.
Great, thanks so much, Kim. I don't know, Parisa, if you had anything you wanted to add to that?
Sure. I mean, I can go through sort of what the current advertised version is and what the alternative is, if that's what everybody would like.
I think that'd be really helpful.
Okay, so as Kim said, the structure is set up by the advertised ordinance, and it's for a board with a specific auditor monitor, excuse me, I always get tongue-tied over that, who investigates on the behalf of the board and reports to the board, and then the board sort of reports out to the public. There are 7 areas, subject matter areas that are important. I'm going to list them, and then I'm going to deal with them in a reverse order because they go from the least controversial to the most controversial. And so investigative and subpoena power, review authority, which means review investigations, like reviewing investigations that are complete, binding or non-binding disciplinary determinations, the ability for the board to receive complaints, the ability of the board to advise on policies and procedures, police policy and procedures, the ability of the board to issue public reports, and the ability of the board to engage with the community. So I'm going to start backwards, like I said, with the least controversial. The advertised version allows the board to hold public meetings and to share information with the public. There's no controversy over that. The ability to write reports. There's some debate about whether the Auditor Monitor should have to write their very own report from scratch or adopt parts of the law enforcement agency reports and sort of provide feedback on how, what they think of the investigation. There's the sort of advising for policies and procedures. The draft ordinance provides the authority to say, hey, this policy or practice doesn't, we don't think that it complies with best practices. We don't think it's based on evidence, and make recommendations about that to the ACPD. Receiving complaints. The advertised version permits this. What's not clear is whether or not when the board receives the complaint, it gets passed to the ACPD or not. And there's some sort of discussion about that. And that's one of the things that I think Kim will address later. There's binding or non-binding disciplinary determinations. The advertised versions don't allow for binding disciplinary determinations, though they do permit non-binding recommendations. There's review authority, and the advertised version gives the oversight board the right to review an entire investigation once it's complete. That's with powers to investigate after it's complete. The alternative version sort of muddies this a little bit. And so it sort of mushes in because it changes the investigative authority. So the original version, which is, I believe, if I'm not mistaken, the county manager's recommendation is that the community oversight board have only review authority of completed investigations, and then subpoena power and investigative power once an investigation is complete. Whereas in the county board alternative, both of which were advertised, but the alternative was not recommended by the county manager, permits the Auditor Monitor to sort of have concurrent investigative authority. So it's like actually investigating while other investigations are taking place. And the subpoena power for both is the power, which they have, is the power to ask the court to compel production of records or people. And that kicks in both versions after there have been good faith efforts to negotiate and work with the ACPD and work with the county manager's office. So in the version that allows concurrent investigations, it's only for 3 kinds of cases that are like concurrent, like cases that result in death, use of force, and severe misconduct, which has not been defined yet. And in the version that has been advertised, that is the not recommended by the county manager version, the board has the ability to recommend disciplinary action, dismiss a complaint, or refer it for criminal charges, which that is kind of an issue, and I will get to that in some of the questions that are later.
Okay, thank you so much, Parisa. I think that's really helpful. It is pretty complex, the situation that we do have these two competing proposals out there. So we appreciate just laying the groundwork. And we really can see from those two proposals that CRBs can take different forms and have different authorities. And I want to make sure that we sort of ground this discussion in an understanding of what do CRBs typically look like, or what do they look like in neighboring communities and nationwide. And we're so fortunate to have Councilman Seifeldein here from Alexandria. I'm hoping he might be able to just take us through an overview of what national trends are looking like, or how Alexandria's ordinance is working, so we can better understand Arlington's proposals in that context.
Good morning, everyone. So delighted to be with you, and thank you for the opportunity to speak and share with you some of the national trends and what we did in Alexandria. So when we began doing this, my team and I started looking at full research on the issue itself. And then just to give you a brief background, these review boards kind of started post civil rights era because some of the federal laws that came on. And our research has shown that based on the Department of Justice report that there are roughly about 150 or so review boards nationwide. And we took a deeper dive into those review boards in details to look at what are the trends, what's working, what isn't. And as you noted, each community kind of gets to decide what's best for them and what is needed. So in looking at those review boards, we went through quite a few of them. So nationally, the most ones that we thought were closer to what we want to see in Alexandria, what Alexandria community would like, are those that we found in the city of Cambridge and the city of Berkeley. And those are the most, I would call liberal or progressive review boards, in the sense that they have everything that the residents of Alexandria has asked for, and some of the things I think the Arlington community members are asking for. That is the ability to issue subpoenas and independently investigate police actions outside of the police itself without having to go through hoops and so on and so forth. So those were really helpful in getting kind of the foundation for the Alexandria review board. But also we had to look at what is within our state, right? Because we usually look at our neighboring jurisdictions or our state to see what the trend is. So we started looking at Virginia Beach, Charlottesville, and Fairfax County. And at the time, those I think were the only three in the Commonwealth that were there. So Virginia Beach was completely out of the question for us. Charlottesville was also a little bit better than Fairfax County, in the sense that Fairfax County was mostly in line with what the county manager is proposing now, in the sense that it's mostly a review body. It'll review the police investigation once it's concluded and then say, these are the policies we're recommending, so on and so forth, but they don't actually get to do their own independent investigation, which is problematic. And I spoke with some of the members there, and they expressed that concern and frustration, and some of them actually ended up leaving the board because the inability to actually make meaningful change. So with that in mind, Alexandria decided to adopt into its ordinance the Independent Investigative Authority, the hiring of an auditor to help the board perform the independent investigations, the ability to subpoena not only records, but witnesses if necessary, so on and so forth. And one of the things that I will pivot to with some of the concern that I have with the manager's proposed budget, which is really, really important, and I think the subcommittee should look at this, is once you have the auditor, and presuming that you have an independent body, who hires them? In Alexandria, we decided that this is going to be an auditor that's going to be hired by the council. The way the city works, the council only hires the city manager, the city attorney, and the city clerk. Everyone else responds to the city manager and reports to the city manager. So if you're truly going to have an independent investigative body, you cannot have the county manager hire the investigator and auditor, and then have the auditor investigator report, respond, and get directions from the city manager, the county manager. That creates conflict. So these is really some of the nuances that you have to look at and make sure that the board gets to decides who to hire, and that person reports directly to the board. So that's really an important issue, because even if you take care of all the other stuff, if you don't have this major part, you're going to have an issue with credibility with the community and some of the findings that may come out. And this is some of the behind the scenes politics and nuances that will be problematic to the success of the board. So hiring of the auditor has to be done by the board, and he has to respond to the board as well. So some of the other differences that I've noted is the exclusions that are in 6910, and then they refers to 69.8C, and I think we'll get into those later, which is what are some of the information that are being reported, some of the information that the body can get to actually perform its duties. And I think we can get into the discussion about why having the county manager hire that person and having those exclusions makes it really difficult for the board to be successful. So there's a really, I give the credit here to the county manager and county attorney. There's really clever lawyering and drafting of this document, in the sense that even if you do take care of these major issues, whether it's investigative and subpoena power, there are provisions and clauses in there that could potentially water down those abilities. So we have to be really mindful of those. And I'll pause here for now so we can have more in-depth discussion about them later after Kim touches on them.
Thank you so much for that. That is really an interesting perspective. And I do want to make sure that we start to turn and talk about sort of what the community's reaction has been to the proposal here in Arlington, and what the community engagement has been like. And we're so fortunate to have Kim here from the Police Practices Group, working group that has been focused on this. Kim, can you give us a flavor for that engagement and what some of the issues have been that the community has raised?
Sure. So first, for the Police Practices Group, we convened for a period of 7 months. And so for 7 months, the Civilian Review Board Subcommittee has been discussing this, talking to experts about this, and we came up with our recommendation. At the end of the day, we did have a majority and minority opinion, but the majority opinion was the strongest possible on everything: full investigative authority, a full disciplinary, the ability to do binding disciplinary procedures. So we went with the strongest that we could get, because we're like, let's empower the community first and have that transparency and trust, because that was so very vital. And then the county manager came back with his recommendation, which had stripped the investigative authority out, left the subpoena authority in. The county board then came back to the Civilian Review Board this month. We met in June, and then we met multiple times, June, July, to work through what does investigative authority, how is that going to work? Because we wanted to make sure that got brought back in. That was really vitally important, and the board made it clear that there was going to be investigative authority. What we don't know is what the board's decision is finally going to be on that. But we put together a chart. We highlighted where we agreed, where we disagreed. There's actually 2 different charts, where we agreed with the ordinance and where we disagreed with the ordinance. And then a chart working through how the investigative authority is going to work in 3 instances. And that would be criminal, use of force, and I can't remember the third one, but 3 instances, 3 examples in real time, and how would this work out? So, so it's been a very long process. We made our presentations to the board. We are still, as we've told the board, very open to questions and further discussion as needed, because we want to actually see this civilian, and we're calling it a civilian oversight board. We want to see this board succeed. That's very important for the community. And I think it's and the community has spoken and said, this is what we want. And that's really important, that the community said, this is what we want. Because I think it's really vital that electeds hear that, and that the police department hears that too.
Thanks so much for those observations, Kim. I'm curious, Parisa, if the Commonwealth's Attorney's Office was engaged at all during the sort of deliberative process. Could you comment on that?
So I was involved in the original PPG meetings that occurred over the fall. I was not a voting member of any of the subcommittees, but I did attend all of the oversight board meetings, as well as the other subcommittee meetings. And I was involved in one of the county work sessions, but the sort of revamped and re-put together PPG subgroup, I was not invited to be a part of, although I did provide some insights in the last meeting that they had before they presented to the board. And my main concern at that point, having sort of seen the chart that, and I don't know if you guys want me to drop it into the chat, but the chart that the PPG and the ACPD sort of agreed on, my biggest concern was really where this intersects with criminal cases, and that the sort of integrity of criminal investigations remain so that I can if make independent judgments and prosecute cases. And we can sort of talk about that specifically. I know it's going to come up a little bit later, but I dropped in the chart sort of where that has the flow chart of how things move through, and really Kim is the better person to talk about this, how things move through the sort of investigative process, where the new proposal is that the Auditor Monitor have sort of co-occurring concurrent investigative powers. And then when it's a civil complaint, and then when it's criminal, sort of how it kicks to the investigating law enforcement and the Commonwealth's Attorney's Office, which, by the way, is an elected officer that is directly accountable to the community. And so in that sense, more independent than an Auditor Monitor who is hired by the county, at least arguably, because there's a direct relationship between the community and the constitutional office. And we'll talk again a little bit more about the need to keep people sort of who shouldn't be at crime scenes away from crime scenes, right? And the need to keep the integrity of a criminal investigation, the need to make sure that the evidence gathered is gathered in accordance with people's Fifth Amendment rights and all the other due process rights that the Constitution affords, and so that we don't trample on those things and then create evidence that can't be used in a criminal prosecution in the end. And that's really sort of my biggest concern. And I think that we've worked all of that out. Kim, you can disagree with me, but there's sort of two avenues where the Commonwealth's Attorney gets involved, and that's the criminal piece. And then there's this other piece, which is a statute that went into effect in March of this year. It was passed in special session, and that's 19.2201C. And what that provides for is that the chief law enforcement officer has to give the Commonwealth's Attorney information about complaints that are made against officers that implicate constitutional rights and implicate the veracity of officers. And so that is something that should have always been happening, because technically, under both the United States and the Virginia Constitution, defendants have the right to potentially exculpatory or impeaching evidence, but it wasn't really happening in a lot of places. And so the 201C statute requires, that when a complaint comes in, we get notified, and we make the call whether that gets disclosed or not, and under what circumstances, and whether it's relevant to a case or is it actually impeaching. But it gives the Commonwealth's Attorney's Office oversight in both making sure that a complaint is investigated, and the defendant is alerted in that particular case, but also gives the kind of oversight where you can see if a law enforcement agency is consistently not sustaining a complaint. Or if like an officer has like 15 complaints and there's, they're consistently not sustained, so that you can sort of dig a little deeper and see what's really going on.
Okay, so it does sound like the investigative authority, the scope of that authority for the CRB is really where the rubber meets the road, so to speak, in terms of sort of where the community questions are. And so I'm just curious, I mean, Kim, can you help walk us through some of the scenarios of concern so that we can understand what's contemplated, what the community thinks might be helpful to add? Can you just take us through a few examples?
Sure. So the first fact pattern that we were asked to look at is when a resident or visitor complaint of allegations of bias, discrimination, or non-criminal misconduct. So when you go to the Civilian Review Board website on the Arlington County site, you're going to see this document that's called Understanding Civilian Review Board Investigative Authority, Comparative Models. And that is these three scenarios here. So we have the county manager proposal, the county board alternative, the Alexandria ordinance, and then the recommendations from the police practices group. And so what we decided in this case, so this is a complaint that originated possibly 911, media or social media, how the complaint is filed. So it can be filed with the police department, or it can be filed with the Civilian Review Board. So the group decided that at the discretion of the Auditor Monitor, and you're going to hear those terms used interchangeably, conducts the investigation concurrently with ACPD's investigation. So what this means is that everyone is privy to the same information. The Auditor Monitor has the ability to participate in interviews and asking questions. And this is full investigation. This is not a review of the investigation after ACPD is done. So that's the first scenario here. And you're going to kind of hear the same thing throughout. So the next scenario is a potential criminal liability, including death or use of force by law enforcement officer as defined by a statute. So again, there will be an investigation, but in this case, the criminal investigation, and that needs to happen first. It needs to go through the court first. We don't want to muddy evidence, but that doesn't mean that evidence is not being collected. It's going to be collected and held until the criminal case concludes. Once that concludes, then that's where the Auditor Monitor comes back in, does the investigation. This again is going to be concurrent with ACPD so that everyone has the same information. The Auditor Monitor can ask questions. And if the Auditor Monitor feels like, well, there's something more here, the Auditor Monitor has that ability to carry out that investigation. The third one is a potential civil liability. So the example that was given for us was the ACPD involvement in Lafayette Park. And so again, investigation. We know that the challenges here is that this has to do with a mutual aid agreement. But again, investigating anything that on the administrative side that would like, does there need to be a policy change within ACPD? Did the officer involved violate policy? So these are all the things that are being investigated. Also, keep in mind that the Auditor Monitor, after conducting the investigation, once it goes through the process with ACPD, the Auditor Monitor then has the opportunity to review. So there's an investigative piece and a review piece after after the report is finalized. And so the Auditor Monitor then has a chance to say whether or not they agree with the police department's disciplinary action, or if they feel that more investigation should have and could have been done. So it's two things going on here, but the Auditor Monitor is always going to have that investigative authority. Now, where the Civilian Review Board comes into this, or the Civilian Oversight Board actually comes into this, is that the Auditor Monitor actually reports to the COB what investigations are ongoing, what's going on in the process. The Auditor Monitor will have access to all of the recordings, so body cam footage, interview recordings, any evidence. Our hope is that the COB and the Auditor Monitor don't have to use that subpoena power. That if there is cooperation and everyone is like, okay, we're going to share this information, that we don't have to go to that step. But we want that subpoena power there because there may be instances where it's needed.
Thank you so much for that. I think that really does help to sort of tease out what are the different scenarios that could arise. And I'm curious to understand if these were, scenarios that Alexandria addressed in adopting its ordinance, and if Mo, you have any sort of insights about them that you could share that could really help us even further deepen our understanding of sort of the issues that are present here.
Certainly, and thank you for asking that question. And we did address those issues. And we noted earlier, we came to the conclusion that the auditor investigator will carry out these investigations. Well, there's a difference to protect the criminal investigation. The police were concerned that information should not be shared with the board members until the investigation is concluded. But we also had to weigh in the public interest in nationally trends of how police has acted generally. So to kind of come to a compromise, we've decided that the information will be given to the auditor, will be kept away from the board until the investigation, the police investigation is concluded. Then the board and the auditor could do their own investigation. So I think there's a difference whether waiting until the criminal case is over or the criminal investigation. I think once the criminal investigation is over and then there's charges, most of the information may become public anyway, and that gives the board and the auditor, the time to kind of go through their investigation and have all the information fresh in witness memories and have access to it. Similarly, when it comes to civil complaints, there are scenarios where there could be a civil lawsuit, which we've had one recently, without a referral of criminal investigation. So in those instances, the investigation would be concurrent with the civil litigation. So there's going to be no hindrance on that at all. So we did address that issue. Really, one of the issues that we insisted on and we had a lot of discussions about is the sharing of information between the board and the police, from the police with the board. And I think we were successful in making sure that the information will be shared. The subpoena power, really, it's mostly geared towards getting witnesses outside of the police department. Since the review board itself is going to be a government entity, and it was given its authority from the council, which has authority over the police department. If they ask for it, it should be given. So there won't be really a need for the subpoena to get information from them. What I noted that's really interesting about Arlington County Manager's proposal, which I think is the proposal right now that the board will be considering with the exception of 69D, is that the exclusions that they have on there, which is 6910, and then makes reference 698C. If you even move forward and have the auditor, by the way, just on the auditor point, it is his duties are not clear even with the board's suggestions and changes. So I think the board will need to look at 6912 and make sure that the auditor duties to investigate are clearly spelled out, because as of now on the existing advertised ordinance, they're not clear, and that authority is actually not given to the auditor to investigate in 6912. It's passingly implied on 6993 in the sense that he will give a report after the investigation is completed. So this is some of the clever drafting I talked about earlier, and you just be careful, make sure that the board goes to 6912 and make sure that the auditor has that investigative authority spelled out. But to the point I was making, 698C pretty much deprived the auditor, even once he gets the investigative authority, from having any of the information on it. And if you look at it, he will not be able to get files on active criminal investigation, which we agreed on, files related to active internal investigations, files related to active investigation by the Commonwealth Attorney, that's fair, files related to police department officer employees who are subject to an active disciplinary process or grievance internally, right? There's no reason for that at all. Files related to civil litigations, that doesn't make any sense. File related to the EOC or human rights investigations, file related to an active Office of Human Rights Investigation involved in the county or the police department, or pending claims for litigation is reasonably expected. So these exclusion really renders the auditor pretty much, doesn't give him a lot of teeth. I don't know how long you have to wait until you get this information. If you're looking at a civil claim, you're looking at least a year or two before that investigation is completed. Similar thing if you have internal disciplinary actions, that could take a while. There could be appeals, especially now that we're moving forward with the, the bargaining agreements as well. So that in itself is going to take another process. So I think really, and I think the subcommittee addressed this, but if you are sitting out there right now and you are going to speak at the public hearing, you have to encourage the board to deal away with 698C, because it hinders the ability for this board, even if you give it those investigative authority, to have any meaningful outcomes or even get information. So the sharing of information is really critical. The other part of that also, the proposed ordinance makes a lot of references to applicable laws and Freedom of Information Act. This is an issue that we've had and dealt with in Alexandria, and I actually asked our city attorney to come up with a memo explaining to the public and our colleagues that the Freedom of Information Act does not prohibit the county or the council, the city council, from releasing information. That is sort of like a privilege that belongs to the government that the government can waive. So once we got that information on a legal memo, I think the council was a little bit more at ease in demanding that information. But obviously to protect certain information, we said that personal identifiers may not be released to the extent that it's going to compromise certain things. And I think that's probably included in there. But that freedom of information, you really have to be careful of how it's worded. And I think the county, when it's reviewing or making this determination, should look at that again. And I think Alexandria's code provides a pretty decent guidance as to how you should tackle that issue. So those are really important issues to the success of the board. I think having a conversation about the independent investigative authority and how that works is great, and it's obviously the foundation, but what happens after that? And I think that needs to be hashed out as well. And I think we did that quite well in Alexandria. So I think you have an opportunity to do that in Arlington as well.
Okay, I appreciate those comments, because I think what it helps to do is tease out that there's at least, two issues here that maybe can get conflated, or it's not completely obvious. So you have the scope of the investigative authority issue, and then you have the ability to access records issue, or the information sharing issue. And I'm curious, and I'm going to throw this question to Kim or Parisa, whether that info sharing aspect of the issue has come up. What has been the discussion about that around the Arlington ordinance?
I can go ahead on that. So yes, it has come up. And we have talked about, we know what if there's a scenario where the police decide they don't want to share information with the Auditor Monitor and the Civilian Oversight Board. What do we do in that case? And that's where the subpoena comes in. But as I said, our hope is that we don't have to go there. You know, the subpoena should really be the last resort. But we have decided that it is better to share information. So whatever complaints come in, because we know that the police have a duty to investigate every complaint that comes in, no matter when it comes in, and that is by statute. And so we thought it best to share information. So we will be sharing information. COB gets information from ACPD. ACPD will get the information from the Civilian Oversight Board in terms of the complaints that come in. Now, about anonymous complaints, we have had discussions on how that works. And I think that still needs to be ironed out. But there is the capability to do that. We know that ACPD does do that. I don't see why on the Civilian Oversight Board, why that could not be also a possibility. So there is that, that still needs to be worked out. Also with, there was something else as well. The independence of the Auditor Monitor is something that we've discussed as well with the county board and our concerns that the Auditor Monitor reports to the county manager. And where is really the independence in that and the conflict of interest in that, because there is a conflict of interest there. So the majority opinion is that the Auditor Monitor reports to the county board. So we will see if the county board decides that that needs to be done. I believe it does. I think that independence is very vital and very important.
Great. Well, I appreciate those additional comments. I don't know if Parisa, if you had anything you wanted to add there. Okay.
I mean, I think Kim said everything that I could have said and better.
Usually the case, I find. You know, since we've got Mo here with his great experience from Alexandria, I just want to ask, are there any other sort of burning issues that you all identified in Alexandria that you would expect to see being discussed in Arlington? I know when we had our press session, you raised an issue, and I just want to make sure that we're getting everything out there, you know, for purposes of community discussion.
No, I think we really hit on some of the great issues, you know, the foundations, the investigative authority, the independence of the board and the auditor who hires them, the sharing of information. Those are really important. But also, you know, we've talked about the voting and who compromises the body. I note that the language used in the manager's proposal, it's a little bit more timid than ours, in the sense that we've made it clear that at least 3 members of the board have to be from a historically disadvantaged communities. And obviously that's really was important for our community. We have that. One of the things that I actually fought against and did not win is that you need a majority, you need more than a majority. So you need like a super majority for the board to take action. That's something that just I thought was unusual, in the sense that even when the council takes decision, it's a simple majority. But here we're making sure, at least there's a demand that there has to be a super majority for the board to take action. That was problematic for me. So I think Arlington can actually take lessons from us and not do that here. So I think those are some of the things that are, you know, kind of talk about once you get past that. Another thing is, obviously, I think Arlington has this already. You have non-voting members who are with some police experience or former police officers, and having that perspective, I think, is important, but also having them not vote is something that will give the board more independence, which is what the community is asking for. But I think the highlights are the ones we kind of touched on earlier.
Well, let me just ask about that voting point. So, you know, how the board votes and how the votes sort of are weighted is important. Kim or Parisa, can you give us sort of any insights into the community discussion in Arlington around that?
That's actually a really good question. And, you know, I have to admit, I hadn't actually considered it yet because I've been so focused on the investigative authority piece of this. But that vote is really important. I don't think it should be supermajority. I believe we had said a 2/3 vote. If I remember exactly, I'm gonna have to revisit the recommendation to make sure. But we wanted to be sure that that however the board voted, that the vote stuck, that it was a strong enough vote. So yeah, so I definitely have to revisit that. So I'm actually, Jill, if that's okay with you, I'm happy to look at that and reply in an email if you want to share that out.
Oh, that's fine. The whole point of this panel is to make sure that sort of we're getting ideas out there and issues out there on the table. So if we're planting an idea for you to follow up on for the PPG, all the better. And I hope that folks out there similarly are taking away points from this panel for further reflection. Let me change focus a little bit because I do want to understand, and it's not entirely clear to me, and I'm hopeful we can piece this out a little bit. I want to understand how the board's work might intersect with or impact the work of the Commonwealth's Attorney's Office, which of course is charged with prosecuting crimes. Parisa, I know you talked about this a little bit, but I think that there's probably a great deal of interest in there and confusion in the community about how that really is going to work. Could you tease that out a little bit more for us?
Well, I guess it depends on whether you're looking at the advertised ordinance or the sort of updated work that the PPG subgroup did. But to give you sort of a sense of how these investigations work, once it's sort of clear that there's potential criminal liability, it's almost like the internal investigation piece of it just shuts down, because you're working really on two different tracks. When you're doing the internal investigation, there's a certain amount of, like, a lack of due process rights, right? Like people can be compelled to say things against their own penal interest in an internal investigation. They can be told, like, you either talk to us or you lose your job. I can't use any of that in a criminal case. So that's why, like, you know, the internal affairs will start investigating, and if it looks like it's going in the direction of a criminal investigation, they'll just shut down that internal investigation and start giving Miranda warnings so that people know that there's criminal liability if they incriminate themselves. And so then it proceeds like a normal criminal investigation, except for the sort of strangeness of the fact that, you know, in most cases, an agency is investigating itself. Like in the last year and a half, I've been very hands-on working with law enforcement agencies when they're doing these investigations, like telling them like what I want to see, you know, suggesting search warrants, you know, asking lots of questions, you know, coordinating with, you know, with law enforcement about, you know, who I would like to see interviewed, you know, what questions I'd like to see asked, and working sort of almost contemporaneously with them in order to get the information that I need. And then also going outside myself to some extent and, you know, sort of speaking to experts and that sort of thing, in order to make sure that, you know, I'm doing all of my due diligence. Once, if something gets charged criminally, the whole sort of like the IA investigation sort of just is on hold until it's determined what happens with the criminal charges. And really, like, if we're filing charges and if we're proceeding with the criminal case, it kind of becomes moot, at least, you know, for the time being, because there's action going on. There's a higher standard of proof. There's, you know, the whole case is being put on. It doesn't mean we can talk about everything to the public. There's plenty of things that go on in the criminal investigation that not only are sort of like unwise to talk about, but also that we have, ethical duties not to say, and ethical duties not to publicize. So, once that sort of criminal piece is rolling, it gets rolling. If charges are declined, then the IA, the internal affairs investigation, kicks back in, and they can give, the law enforcement agency can compel cooperation sort of on pain of losing your job. And then that's also when, under the what I understand the sort of new PPG recommendation is going to be, like, that's also when the auditor monitor's role kicks in again, is as soon as the IA investigation. So as long as there's an IA investigation going on, the auditor monitor is investigating or choosing whether or not to investigate. It seems like it's broad enough to let them determine that. That's when the auditor monitor is involved. Well, there's a criminal investigation or criminal charges pending, then I think that it sounds like, based on the Alexandria model, like the auditor monitor can play a passive role and receive information but not share it. And I think that's, and if I'm not mistaken, that's also what Arlington, the PPG, was envisioning. Not so much that the auditor monitor would then be going out and doing their own independent investigation, but that the auditor monitor, along with IA, could passively receive information so that they're not like behind and sort of like left catching up, but they're not really active at that time period and during that criminal investigation. What's interesting is and I think what adds an additional layer of independence is the criminal incident response team that's been organized with 11 different law enforcement agencies in Northern Virginia. And the point of that is so that an agency is not, particularly in use of force cases, investigating themselves. And so if something, God forbid, happens in Arlington, the primary investigators are going to be law enforcement agencies outside of Arlington. So like Arlington will secure the scene, right? If there's a crime scene, and they'll start collecting evidence so that there won't be, like physical forensic evidence, so that nothing is lost, right? Because if it's like outside and it's raining, if you don't act quickly, you're going to lose evidence. But so they'll start sort of securing that scene, and then a group of other law enforcement agencies will come in and do the actual investigation, and they'll keep ACPD updated. And I've met with them, and it would be the same kind of thing as if I was with ACPD. So I would be talking to them, and they'd be sharing information with me and going through as if it's a criminal case, if it looks like a criminal case. And then it gets to that same sort of point where if there are criminal charges, there are criminal charges, and the critical incident response team is working with the Commonwealth's Attorney's Office. And if there are not, and there's a declination, or there just doesn't seem like there are charges, then they're acting sort of in the IA capacity and doing those investigations sort of in an eye, with the different kinds of warnings and a sort of different due process standard. And then again, as that piece is going on, that's not criminal, the auditor monitor would be working with a critical incident response team. Is that right, Kim? I mean, yeah.
Yep, that's right. So yeah, auditor monitor's investigation would not kick in until after all of the parts of the criminal investigation, whether it goes to court or not, all that decision making is made. And that's because we don't want the auditor monitor to go in and start muddying evidence. So we wait until all of that is wrapped up, and then the investigation kicks in. And it's looking at the administrative side of things. We will get the CERT report. So the auditor monitor does get a copy of the CERT report. but it's really looking more on the administrative side. Was policy violated? And if so, how severe was that policy violated?
So it sounds like, Kim, then that there's at least some basic support within the PPG on the notion that there should be a difference between how an investigation is treated if there's criminal element to it versus civil. Is that fair to say? I just want to make sure.
Yeah, that is fair to say, yes.
Okay.
And really, it has to be that way, because otherwise, you're facing situations where if evidence can be easily tainted. You're facing situations where evidence can be collected based on one standard, but then it's totally inadmissible. Like the Auditor Monitor and the IA could go out and find fantastic evidence, but if it's not done consistent with the way that things have to be handled in a criminal fashion and consistent with Miranda warnings and that sort of thing, it makes it absolutely impossible to charge and prosecute a criminal case, or potentially makes it impossible. Not definitely every single time, but it makes it really hard to pursue a criminal matter.
Got it. Well, that makes sense. You're sort of walking a fine line there with someone's due process rights that attach if there's a criminal case, with the need also for the oversight. Understood. Well, there's so much to unpack with this proposal, and it's such an important one. I really appreciate your time here today, getting into even just some of the details with us. If others in the community who are hearing this discussion or hearing other discussions about it want to get involved, I think we've heard a little bit today that there are still opportunities to do so. Kim, you're probably the closest to the public process. Can you walk us through what additional engagement opportunities are still available to the public?
Sure. So the county board is going to be meeting on July 17th to go over the new, the revised ordinance with the updated information. So please make sure, email, write, call, sign up to talk at the meeting on the 17th. It's really, really important that this investigative authority piece be added. Also really important to let the county board know that the auditor monitor should report to the county board and not the county manager. And keep in mind, the way that this ordinance is written, it can be reviewed in 2 years. So take notes on what's going. If things need to change, please make sure that you keep abreast of what's going on, because if things need to be changed, we have time to make changes, but we want to be sure that we really want to go into this strong. And as was pointed out with all the different clauses and everything, and Mo, thank you for that, it makes it difficult. So there is going to be some fighting that's going to happen to make this happen. But yeah, please write, email, sign up to speak July 17th.
Great, thank you. And I think also that there may be a portal online, but correct me if I'm wrong, where folks can submit written comments. Is that correct?
Yes, that is correct. You can support written comments online as well as emailing the county board.
Okay, and I think Maggie, if you could help me out with the slides that we had been projecting earlier, had a few sort of very key links on it. And the third link, and we always make our materials available on our website, arlingtondemocrats.org, but that third link is the Arlington County website on this topic, and it includes the link to the public comment portal, as well as information about that public comment period at the upcoming county board meeting that Kim was mentioning. So if you are interested in getting involved, it'll be on that slide. I see that it's also been put into the chat. I see that a number of questions also were put into the chat. I would encourage everyone, because we are so short on time today, to get those questions in front of the decision makers, right? To get them in front of the county board as they are considering what to do with this ordinance, and to make sure that the PPG, to the extent that they're also still meeting and providing inputs to the county board, are able to sort of consider those issues, and to really to get drill down with them, so the county board is able to make a really thoughtful and well-reasoned decision. We are coming up just on that 60-minute point. I do want to pause a moment and see if our panelists had any sort of parting comments that you wanted to leave us with, any additional thoughts that we hadn't had an opportunity to cover that you'd like to do so.
No, I'll just add that the community, if you're going to speak about some of the great things that Kim talked about, emphasize that the auditor not only must not only report to the board, but must be hired by the board, i.e. this will become the fourth, I suppose in Alexandria, I'm not sure in Arlington, but it's the fourth member that the board will hire directly. I think there's still going to be an influence if the manager hires the independent auditor. So it's two aspects of it, the hiring and the reporting. And also, I think there could be a discussion about what is actually included in the report that the auditor investigator puts out there. And I think that's important. There's a provision there that also talks about maintaining confidentiality, which could be problematic to what would be included in the report itself. So that's something to look into as well. Thank you.
All right, and thank you so much again for virtually crossing jurisdictional boundaries to come and share your insights with us. I think they've been great. I think some of the issues that you raised have been echoed in the questions that we've seen in the chat. So really important perspective. Parisa, did you have anything that you wanted to add?
Nope. I am just really grateful that we are talking about this and having these open and thoughtful conversations. I'm just really excited and grateful to the community and to particularly Kim and Mo for the work they've done in their respective areas. Agreed.
And I, for one, did not know a lot about this topic going into this. Confess that there's still aspects of it that it's so dense that it would require some additional learning. But I think this has been a really great level setting opportunity on a complex topic. So I appreciate all of your time. Kim, I'm going to give you the final word. Is there anything else you wanted to add? You've not yet had an opportunity to do so.
No, nothing to add. Just emphasizing contact county board.
It works.
They do listen. They do listen.
Absolutely. We've always found that to be true on any number of topics. And so they want to hear from you. They've set up this portal to accept comments. Please get your questions, comments in there to make sure that we really do come up with an ordinance that serves the needs of the community in an important area. So I want to thank again our panelists for joining us on a Sunday morning, and also for your work in preparing for this event, and to thank all of our audience for coming by. As always, we appreciate seeing you at our morning mugs. I want to remind everyone, please tell your friends and neighbors that we do post these videos to the Arlington Democrats YouTube channel. So if they are interested in learning more about this complex topic, that they could check out this video and learn from our panelists as well. And I want to remind you that we actually have a great lineup of morning mugs this summer. We are going to be together pretty much every Saturday, meeting various Beyond Arlington candidates. So it should be a great time. All of the morning mug information is available on our calendar, arlingtondemocrats.org/calendar, or our Facebook page. I want to thank everybody very much for coming out today, and I wish you a really wonderful rest of your Sunday. Thanks so much.
Thank you, everyone. Ija.